Okay, let's go on the record. We're here on State versus Hannah Freeman. Ms. Freeman is here on case 697-119. She's here with her lawyer, Michael Kinlan. Assistant County Prosecutor Patrick White is here for Brandon Pateo, who is in trial in another courtroom. Ms. Freeman.
Right from the start, you can tell this isn't just a routine misdemeanor case. The judge is already digging into the background because these charges point to something deeper, a relationship that completely spiraled out of control. And trust me, when a court starts talking about emotional behavior mixed with criminal allegations, things can get messy fast.
And pled guilty back in June to disorderly conduct, a minor misdemeanor in count 1, obstructing official business, a second-degree misdemeanor in count 2, and possessing criminal tools, a first-degree misdemeanor in count 3. She was referred for a pre-sentence investigation, which the court has received and reviewed. PSI is extremely detailed. Counsel, have you read the PSI?
Yes, I have.
Yes, Your Honor.
You find it to be complete and accurate?
I do, Your Honor.
I find it to be complete. Some of the police report was not accurate, hence the reason for the amended charges.
In what way?
We provided text that showed that the alleged victim had lied about the stalking.
Here's where the tension really starts building. The defense is claiming parts of the police report were inaccurate, but the judge immediately wants specifics. In court, you can't just say, the report is wrong. You need evidence, timelines, text messages, something concrete. And you can already hear the judge getting frustrated trying to separate facts from emotion.
And some of the other issues.
Well, what part of this document is not accurate?
Just where it relates to the police report.
Pardon me?
Just where it relates to the police report.
I don't understand what you're telling me. There's 4 single-space type pages that looks to be largely taken from the police report. Are you telling me the entire PSI is inaccurate?
No, just where the alleged victim told the officers that she was stalking him. They were still engaged in a relationship at the time. She had planned on spending the night at his house that night with his permission. It's not much.
How about the flock camera part on the bottom of page 2, where flock camera plate readers showed your client's vehicle to be on Westlake City School properties 33 times on 19 different days over the past 30 days, up to and including November 7th at 4:07 p.m.
That is accurate,
Okay.
but he had invited her there. She was there.
Now this is the key issue in the entire case. 33 visits to school property in just 1 month sounds alarming, but the defense insists she was invited there. That's what makes cases like this so complicated. One person says it was mutual contact, the other says it became harassment. And the court has to figure out where that line was crossed.
He invited her to school
Yes.
30 times.
Yes.
Mr. White, do you know anything about this?
Your Honor, what the state could say at this time is that the defendant, on occasions over this period, did in fact invite the defendant, excuse me, the victim did invite the defendant, but the state will contend that the defendant was there and her continual presence across this time did cause the defendant continual anguish and mental stress.
Is there a dispute over whether she took his property?
No, Your Honor.
No, there's no dispute over that, Your Honor.
Why didn't your office have her plead to theft? I know this wasn't your case, but I'm here dealing with the confusion. What happened?
Your Honor, in this case, the defendant and the victim were engaged in a relationship. They broke up over the pursuing months. The defendant did not get the realization this relationship was over. At different times, she did steal numerous items from the victim in this case. Our office reviewed that. We did see those actions more as a continual pattern of conduct in order to get the victim back into her life.
Is that accurate?
And not completely our.
And we can stand in this county, Mr. Kelly.
Yes, Your Honor. It's our opinion, and the facts would have shown if we would have went to trial.
Notice what the defense is doing here. They're not denying the backpack incident happened. Instead, they're trying to explain the emotional context behind it. According to them, this was a reaction fueled by jealousy, heartbreak, and anger after discovering another woman at the apartment. Emotion may explain behavior, but legally, it doesn't erase consequences.
He did take his book bag for about 3 minutes. She tried to return it. She only took it once she found another girl at his apartment. She was on her way to spend the night there that night. They had agreed on it. She went over there, and he texted her, told her not to come, and she realized he had nothing over there. She got mad, went in this car, took the book bag, only as a means to get him to talk to her, and then she tried to return the book bag 5 minutes later, and that's when he called the police.
Okay, I'm led to believe by the pre-sentence investigation that this relationship between the alleged victim and Ms. Freeman ended in April of 2024. Is that correct?
That is not correct, Your Honor. It ended on November 6th, 2024. And that's why if you review the discovery that I provided, the text detail of everything. And that's why we had to negotiate a plea with the charges that we have and that she pled guilty to.
Okay, the pre-sentence investigation indicates that your client took 2 backpacks, a red and a black backpack containing a Chromebook laptop computer, an HP laptop computer, the victim's wallet, and a set of car keys to his car, apartment, and work school. Is that correct?
That is correct, Your Honor.
I haven't seen any of these text messages. You haven't filed a sentencing brief or memorandum?
Well, they were in the discovery that I filed, the defendant's discovery.
Okay, Mr. White, what would the state like to present? Is there anything else?
Thank you, Your Honor. I will say for the record, the state is in compliance with Marcy's law in this matter.
The prosecutor's tone here is very revealing. He repeatedly calls the relationship toxic, but instead of demanding harsh punishment, he focuses on mental health treatment and supervision. That usually means the state believes the behavior was serious, but also believes emotional instability played a major role in how things escalated.
Your Honor, obviously this was a difficult situation. This was a toxic relationship. Over the period from April to November, this defendant engaged in conduct that was disturbing and concerning, and state believes there's a heightened concern because she wasn't employed as a teacher at the time. We understand that the victim in this case did at points re-engage with the defendant over these months. But the state is comfortable with this plea offer after extensive conversations and pretrial meetings with the defense counsel, because Ms. Freeman, and it's our opinion, has mental health issues that need to be addressed. I think that's evident from the PSI. I think that's evident from the facts in this case. We do understand that she has taken steps to do that, and as part of this plea, we did make it a condition for supervision in the form of community control, continued mental health treatment, and that is what we'll ask for at this time, Your Honor. Thank you.
Okay, Mr. Kinlan, what would you like the court to be aware of?
Class 27 years old, she has a master's degree. She was previously employed as a fourth grade teacher. She lost that job as a result of this incident. She's got no other record other than a noise complaint from several years ago. This is a negotiated plea based upon the facts, and based also upon the negotiation that they did with the prosecutor's office. I believe it's a fair resolution. You're not going to see her back again. She was at the school numerous times helping him with his classwork. There was a principal who was contacted, also listed in discovery, who I had subpoenaed in this case was going to trial, who would testify to that fact, that he talked to the victim and the victim told him no, she was there helping him. So there was no stalking in that regard. But she did take his book bag in a heat of passion, she did, when she found out he was still seeing this other girl when she was supposed to be over there that night. She wasn't thinking, and did so in an emotional state. She is in mental health counseling. She regrets this incident, and I don't think you'll see her back here now. Thank you.
Okay, Ms. Freeman, you have the opportunity to speak before we announce your sentence. What would you like me to know?
I regret the incident. I definitely acted out of emotion, and I regret that decision that I made that night, and I will take steps necessary to move on from this incident, and you will not see me back here again.
Okay, thank you. Okay. Court has considered this matter.
And here comes the sentence. GPS monitoring, house arrest, mental health counseling, jail time, and strict no-contact orders. The judge is making one thing crystal clear. Regardless of the relationship drama, the behavior crossed boundaries that the court considers dangerous and unacceptable.
This is frankly a bizarro breakup between two professionals. The pre-sentence investigation does not paint a pretty picture of your behavior, Ms. Freeman. You should have known that was over. It's my understanding that the victim had someone else in his life. I'm going to place you on 18 months of community control. You'll be ordered to have no contact with Mr. McKenzie, the victim. In this case, as a condition of community control, you are to wear a GPS device for the first 90 days. You'll be on house arrest with work release. You'll be ordered to undergo mental health counseling, particularly to establish healthy boundaries. And you will serve the first 7 days of this term of probation in our county jail. You are ordered remanded.
We hadn't agreed sentence.
You didn't agree with me, Mr. Ken.
Whoa! The energy in this courtroom just completely changed. The defense attorney tries to pull back the plea after hearing the sentence, basically arguing the judge misunderstood the facts. But the judge fires back immediately, and now this turns from a sentencing hearing into a heated courtroom confrontation. You can literally hear the frustration on both sides.
Lynn and I am charged with sentencing.
At this point, Your Honor, I'm going to make a motion to withdraw her plea. We'd rather go to trial.
Because you don't like the sentence?
No, because we don't like the way the court has interpreted the facts.
Mr.
The
Kinlan,
facts are not correct.
did you talk to me about sentence before you pled your client?
You were not available, Your Honor.
I'm available all the time, Mr. Kinlan. You chose to plead your sentence, your client.
We only met with you one time, Your Honor. At this point, we'd ask to withdraw her.
I'm offended that you would make the insinuation here that I don't work enough.
I'm not making that insinuation.
When was this case indicted?
December.
Yeah, half a year ago.
Your Honor, I'm making.
Did you make any effort to talk to me in the last 6 months about how I would sentence your client?
Yes,
No.
We did.
You did? When?
When I asked you to take her off GPS back in April.
Okay, and I did.
Yes.
But that wasn't about sentencing, was it? I just asked you, did you make any effort to talk to me about what sentence I would impose after You negotiated a plea deal with the state of Ohio.
No, we did have an agreed sentence with the state, we asked the court to go along with the agreed sentence, as it's usually a plea.
Didn't ask me, sorry.
A plea is not knowingly voluntary.
Your bad practice is not my
I
problem.
don't think it's my
You
bad
wanna
practice.
remain? We're done.
Listen, hold on.
Case shows how quickly a toxic relationship can turn into a criminal case when emotions, jealousy, and boundaries collide. One side sees obsession and emotional instability. The other sees heartbreak and mixed signals. But in the end, the court focused on accountability and public safety. What do you think? Was the judge too harsh, or was this sentence justified?